Hello friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the issues with judges' recusal. So what is meant by recusal? Recusal is the process of a judge stepping down from presiding over a particular case in which the judge may have a conflict of interest. So this is recusal. For example, if a particular judge is assigned to hear a particular case and if the judge is not willing to hear the case and if he or she withdraws himself or herself from that particular case, it is called recusal. And in India, in the Supreme Court especially, we have seen recently many cases of recusal. The judges were not willing to hear the case and they were passing on the duty assigned to themselves to some other judges. So we will discuss this issue in detail. We will see what are the concerns associated with this and is it a healthy practice. But before we begin, this is our channel StudyIQ and we are providing pen drive courses for various competitive examinations including SSC, bank courses, UPSC Civil Services, various state PSCs, NABARD, RBI Grade B examination and also for various professional courses. You can visit our website www.studyiq.com for more details or you can also make a call to any of these numbers for more information. And also the month end sale is going on, so you can avail a 60% flat discount on the pen drive courses. Please visit our website or make a call for more information. Now moving on with our topic, we have already discussed what is meant by recusal of cases. So we will see now what are the recent cases of recusal in India in the Supreme Court. One recent case was the appointment of M. Nageshwara Rao as the interim director of CBI. So this case was challenged in the Supreme Court and 3 judges have recused themselves from the case. So what happened in this case? Chief Justice Ranjan Gogoi himself disqualified and he stated that he is a part of the selection committee tasked with choosing the new CBI director. So stating this reason, he disqualified or recused himself from hearing the case and he assigned a bench presided by Justice A.K. Sikri in order to hear the case. But what happened? Justice A.K. Sikri also recused on the grounds that he was a part of the panel that removed the previous CBI director Alok Verma from his post. So both CJI and also the CJI nominated Justice A.K. Sikri recused themselves from the case of hearing the appointment of M. Nageshwara Rao as the interim director of CBI. And thirdly, Justice N.V. Ramana was nominated and he also recused himself from this hearing stating various personal reasons. And in 3 of these recusals, none of the orders of recusals were made in writing by the judges. So this was one recent case and another recent case was with regard to the hearing of dispute over the land in Ayodhya, the Ayodhya issue. In the Ayodhya issue, Justice U.U. Lalit recused himself from hearing the dispute and he stated the reason that he had appeared for the former Uttar Pradesh Chief Minister Kalyan Singh in a related contest. So this was the reason stated by Justice U.U. Lalit. And in this case also there was no specific written order that the judges had provided regarding the recusal. Now let us understand what are the concerns associated with such type of recusals made by the judges. The first concern is that it undermines the judicial independence. So if we remember, the oath taken by the judges of Supreme Court and the High Courts, they promised to perform their duties in order to deliver justice without fear or favor, without any affection or ill will. So impartiality is the most important promise that is made by a judge entering on the office in Supreme Court or in the High Court. So they are supposed to act impartial in delivering their duty. So such type of incidents where the judges recuse themselves from hearing of certain cases undermines both the independence and the impartiality of the judges. So judicial independence and impartiality of the judges are put into question when they undertake such type of recusals. And secondly, there are different interpretations given for the recusal of judges. Let us see what are they. First of all, there is a rule that no person should be a judge in her own or his own case. So you cannot become your own judge. And what happens with certain cases is that somebody else's case becomes judge's own case as the proceedings begin. So that is one concern. Secondly, there are also certain cases where the judge must have appeared for the litigants at some earlier stages of the same dispute. So, in case of Ayodhya land dispute, we have seen that Justice U. Lalit had recused himself from hearing the dispute. This is because before becoming a judge, he had appeared for the former Uttar Pradesh Chief Minister Kalyan Singh in a related contest. So, this is also another case which has been justified or stated by the judges when they recuse themselves from hearing of cases. So, even in this case, there is no rule to determine when a judge should recuse himself in hearing certain cases. So, different interpretations remain. So, there are no rules, or we can say there is an absence of a rule or a guideline that will determine what should be the circumstances where a judge can recuse himself from hearing a particular case. So these are some of the concerns associated with the recusal of judges. Now let us understand in this situation what is the way ahead or what should be done. First of all, it should be made sure that the judges does not act on the interest of anybody else. So recusal of judges should not be an opportunity for the litigants to have their judges of interest or their favorite judges on the panel of hearing. So this situation should be avoided. The parties or the litigants should not be able to pick benches or judges of their choice. So this should be the first thing. And secondly, the judicial officers must resist all manners of pressure. So this pressure can be from the part of government, from different stakeholders, from litigants, from the public, civil society, from the media. So judges should be able to resist all kinds of pressures and they should duly deliver their duty. And resisting the pressure is a constitutional duty of the judicial officers or the judges. So if they do not deliver their constitutional duty, they are causing harm to the independence of the judiciary, and this will undermine the constitution itself. So the decisions of the judges should not impact the independence of the judiciary. And independence of judiciary is a fundamental feature of Indian democracy. Now, the most important thing is that there should be a proper guideline or proper set of rules that should determine the procedure for recusal and on what circumstances the judges can recuse themselves from hearing the case. So there should be a proper guideline or set of rules that should give a clear idea on what can be the situations or circumstances where the judges can take a decision on recusing themselves from hearing of cases. So this is the most important thing, and this should happen at the earliest. So this will bring down all the concerns and the controversies around the recusal of judges from hearing of cases. You can find the PDF of this lecture on my Facebook page, and for any queries regarding your UPSC preparations, you can get in touch with me on my Facebook page or you can email me at joyce.studyiq@gmail.com. Thank you.